Thank you.
You're welcome, my lady. I'll trot through those in about 10 minutes, if I may.
Yes, of course.
But first, I'm just going to deal with what I advertised at the end of this morning, which was, we say three reasons for your ladyship that you're confident that the approach adopted by Sir Jonathan was correct. The first is it's consistent with the approach adopted by Moylan J. Could you take the supplemental bundle, please, and turn to page 61.
Yes.
Paragraph 88 and 89. Very happy to read these out to the court if you want to read them tacitly as you like. But this is the first part where Mr. Justice Moylan deals with this case.
Did you say 88 and 89?
88 and 89. I agree with Mr. Point that I'm conducting a rehearing.
Yeah, we'll read it.
I'm grateful.
I just wanted to...
Yeah, just those two paragraphs,
Yes,
and then 3 over the page. And then if you'd very kindly turn to page 94, para 94 on page 63, it's paragraphs 94, 95 and 96.
Interesting, isn't it, that the learned judge was at pains to not only say it was fair in 2010, but he thought it relevant to decide or consider whether or not it remained fair for his purposes in 2016.
Yes.
And that view was formed on a wholly false basis.
Well, my lady, no, with respect, because I submit that what he means in remains fair is to be found in paragraph 96.
Right, thank you. But he still was making all these assessments on a materially inaccurate basis.
My submission to the court is if you look at 88, 89, 94, 95, 96, none of this analysis is undermined or affected in any way by reference to the non-disclosure that by then had occurred, because none of it is dependent in any way upon an analysis of the current value of CBA as at 2016, which is that with which in respect to which there was non-disclosure. And just to deal with that point, if I may, what's said is that Moylan's judgment is unreliable because it's tainted by fraud. But we say that that just isn't right, because just by reading those paragraphs, it's clear that what he was deciding there was the point of principle. Had she received a fair share? Did it remain fair? On that basis, the only defect that needed to be corrected is in respect to the trust. And it was completely unaffected by any considerations in relation to the 2016 value of CPA. I said that there were 5 reasons in relation to that, and in the core bundle, at 99, we set all this out in our skeleton argument as to why the 2016 value of CBA was irrelevant and unconnected to the assessment that he took, the core assessment there at 94 to 96. And I won't, you may have looked at these already, but can I just direct you to those again as why we say it had nothing to do with it, because he specifically doesn't justify his decision by reference to the current assets. Why not? Because he has decided that a fair sharing took place in 2010, and that he didn't need then to consider what proportion of the 2016 shares the wife was receiving, because it wasn't fair for her to share twice. We say that that reasoning in 88 to 89, 94 to 96 remains valid, and the fact that Sir Jonathan Cohen's decision was consistent with it is an indicator that he's right in his determination that the 2010 division of assets was a critically important fact. The second indicator, my lady...
Can I just, because I want to make sure I've got the right note.
Yeah.
You say that that reasoning in paragraphs 84 to 86.
88 and 89.
Yes, you did say 84 and 86 just, but it's 88 to 89 and 94 to 96.
94 to 96. I'm sorry
Yeah.
if I misspoke then.
No. It's just that I want to be absolutely clear that that's what you're saying. And will you just repeat what you've just said, Mr. Bishop?
What I just said was that was, in response to my Lady Justice Carr, that this was unaffected by consideration of what the 2016 value of CBA was. It was decided as a matter of principle, and on that basis we say the fact that Sir Jonathan Cohen adopted the same approach, and these two highly experienced judges both saw this, the sharing as having come to an end in 2010, albeit via the enlargement in 2016, that is a reason to believe that Sir Jonathan got this right, not just that he was within his boundary of discretion, but that he was correct in his analysis that sharing had been satisfied. The second reason...
Hang on.
I beg your pardon, my lady, sorry.
So not only was it within the band of reasonable decisions, but he got it right.
He got it right.
Yes, that's what you're saying. Yep.
Another reason why we say he got it right was because his decision is absolutely on all fours with H&H. And then,
JC's decision?
Big one.
JC?
Yes,
Forgive me.
Sir Jonathan Cohen.
Sir Jonathan Cohen.
Yeah. Do forgive me if I inadvertently call him Cohen J at any stage. But
No, it wasn't that. It's just when you said his decision. We've got
quite.
several male judges who we've got to consider their judgment.
Yeah.
So it's Sir Jonathan Cohen's judgment you're considering when you say also he got it right because?
Because of H&H. And can I ask you to look at that now? My learned friend didn't take you to that, and my learned friend Mr. Mitchell didn't take you to this, and he seeks to draw what I respect is an invalid distinction in relation to this case. And in fact, it's a very important authority. It's in the authorities bundle behind tab 1. And can I ask you first to go to paragraph 71?
Yeah.
Thus far in his analysis, I agree with Mr. Marks. If the division actually implemented in March 2008 was fair, then there is, for the reasons he has given, no principal basis for going behind it. And subject only to the question posed in the last paragraph, I am satisfied that the division implemented in March 2008 was indeed objectively fair, amounting in substance to an equal division of the matrimonial assets as they were then worth. And so the first point then is that the reason it was objectively fair was because it was fair in proportions and it was fair in terms of value, then value. Just like the assessment in this case. So when Sir Jonathan is looking at what each party got in 2010, leaving aside the trust, which the defect remedied in 2016, he was able to say what proportion did each get and what was it then worth. And he was able to, on that basis, come to his conclusion that it was an objectively fair sharing.
Can I just go back to a point I raised this morning? When you say it was an objectively fair sharing, are you describing that in purely financial terms? Or are you drawing into that any consideration of what is now being called conduct?
In purely financial terms, but as I'm going to advocate to you in a moment or two, conduct is a complete red herring in this case and isn't something that should have been taken into consent. And the authorities, I think, will support my submission in that regard. But we'll look at that I think in about 15 minutes.
So the answer to my lady is that, yes, you're saying in the black and white valuations and application normal principles, absent conduct, this was fair.
It was.
2010. So that's the answer, my ladies.
It is, and I'm sorry if I wasn't clear. Yes, in financial terms, that's all I'm talking about. That did she receive her fair share of the fruits of the partnership in 2010? Yes, because she got 45% and the husband had a bit more illiquid, risky asset on his side, and the values were correct or sufficiently correct to be able.
But we're talking about actual value.
Yes.
And as you say, proportion.
And proportion.
You've been clear. It was fair, objectively, so far as proportion and value 2010 was concerned. Necessary adjustment in 2016 to reflect the trust.
Correct. There is another point going to fairness as well, and that is this. Would you mind going in that same authority to paragraph 20, sorry, page 20, paragraph 64. But here, as he accepts, that's Mr. Marks, the argument he seeks to make will succeed only if he can establish, as he says he can, the objective fairness of what took place in March 2008. And central to his argument as to why in these circumstances the court should not go behind the division is the proposition that, having actually implemented the division, the husband has ceased to gamble with the undivided share of the wife in the assets. With the result, he says, that each should bear the consequences, good or bad, of any subsequent changes in the value of their respective portfolios. So this is another aspect of why the 2010 division was fair. It was fair because of value, and it was fair because of proportion, but it was also fair because after that division, this wife was off risk as far as the fortunes of CBA
Well, that's his argument. The argument is put forward in paragraph 64. How does Sir James Mumby deal with it?
Well, he deals with it by saying, I agree that it was, I'm satisfied that the division implemented at 71, but then at 105 is his disposal.
Yeah, I know that, but these particular arguments, you placed emphasis,
Yeah.
Mr. Bishop, on the, and having actually implemented the division. So that's the argument that is made on behalf of the husband in H&H before Lord Justice Mumby. Was he president then?
No, this was...
So Lord Justice Mumby.
Yeah.
So thereafter, where his is valuation of that argument? Because there's no use putting it to us an argument that was made in the case unless it was accepted.
Well,
Do you say it was accepted by paragraph 71?
I do, yes.
Yeah.
I'm
Okay.
being corrected by, I'm being, sorry, and it might have been slightly unhelpful to take them in sort of back to front order.
May have been, but there we go. At least we know. So
Apologies.
there's the argument, and you say that paragraph 71 is the positive endorsement of that argument.
I do. And then if you go on to 105, please, my lady,
Yeah.
a highlight part.
Yeah.
This is relevant as well. At this juncture, I must pull together the key points for the reasons already given. I've concluded that if the division actually implemented in March was fair, there's no principal basis for going behind it. Subject only to the question of whether the wife is entitled to a share in the husband's business, that is, a share in either A, B or C, the division of the matrimonial assets in 2008 was objectively fair, amounting in substance to an equal division of the matrimonial acquest as they were when they were then worth. And then the question then becomes whether the wife should be entitled in either additional surplus capital, the other assets of the business, the future income. And then if you go, please, she's not entitled to future income, that's Roman 4, but Roman 5 is important. Conversely, as to B, these are in principle capital assets which the wife is entitled to say should be brought into account and which were not brought into account in March 2008. What are they worth, potentially, Mr. Howard says, etc., etc. And given that she's entitled to them, and she didn't get, and it weren't brought into account, the capital assets follows the mind which she has a claim to some part of the additional surplus capital that has accrued since March. The share should, as a matter of principle, reflect the extent to which, because of the division in March 2008, did not extend to her share in the capital assets. The husband thereafter continued to gamble with the wife's undivided share of the assets. So the bit that was missed out and the growth in respect of the bit that was missed out is then shared by, it's described as Lord Justice Mumby. I think it's Mr. Justice. No, Lord Justice Mumby. Lord Justice Mumby.
No, he did sit in the Court of Appeal before he was made president,
Yeah.
so it would be Mr. Lord Justice Mumby.
By Lord Justice Mumby. And we say, if you look at paragraph 105, he performs the exact same exercise as Lord Justice Wilson in Kingdom, i.e. he asks himself, what is the necessary enlargement? And the wife there got an enlargement because certain assets were not brought into account in the 2008 division, just like the Hardy and Eagle Trust in this case. And the growth on that unshared element was also shared. And then the wife got shared. So there are, we say, direct parallels with this case. Both Mr. Justice Moylan and Sir Jonathan Cohen perform the same exercise as Mr. Justice, or Lord Justice Mumby, assessing the objective fairness of the division that took place and to the extent that it required enlargement, make provision for that. But otherwise, leave it alone.
So you're saying that's what Lord Justice Wilson did, really, from paragraph 36 on in
Correct.
London.
They're all doing the same thing. And that is, if you assess in your discretion that a previous division affects objective fairness, then leave it alone, save to the extent that it needs to be enlarged. And my own friends seek to sideline H&H by saying, oh, well, that was a case where there wasn't material non-disclosure, but that's a facile distinction in my respectful submission, because of course Sir Jonathan Cohen knew the full picture in 2022. He knew everything that had happened. And
But
he
yes,
was...
well, Mr. Mitchell says, yes, he did, but he fell into error because he didn't put it into the balance. That's the whole point of what Mr. Mitchell is saying, which is why he said that it was startling. Is that the word he used? Right at the outset?
Shocking, is it?
I think it was startling, but
Yes.
startling, shocking.
It was nothing of the sort. It was an analysis in line with Kingdon and H&H looking at what was done in 2010, assessing objectively its fairness, recording the fact that it was enlarged in 2016.
Do you accept, Mr. Bishop, that the court, when it deals with cases of deliberate non-disclosure, does go into a different gear, if you like? It may result in X, Y, or Z, but the court has got to go into a different modus of operation. That it's alert, obviously, to the fact that if the person who's made a material, deliberate non-disclosure may not be credible, that's obviously something that they've got to be aware of. It's aware of the fact that the situation may have thereby been irredeemably changed in perspective from that which a court had previously thought before. But it does or should deal with things differently. Do you agree with that proposition?
Well, I agree that there can be adverse inference in those circumstances if the judge feels that he still doesn't have the full picture. But I don't think that's what your Lordship's asking me.
No, what I'm asking you is, do you agree with the proposition that the court, upon, in the position of Mr. Justice Moylan as he was, Sir Jonathan Cohen, should be on a state of high alert to not only the practical consequences of the non-disclosure, but the fact that it puts a completely different hue on what's gone before, and that should, get to the bottom of it. It may result in exactly the same decision, but that there's got to be a demonstration that that's happened.
I don't think I do agree with that proposition.
Why not?
My lady, with respect. I think that consideration comes in at the set-aside stage.
No, forgive me. One of the points, and it's me, Mr. Bishop, not you. One of the points that Mr. Mitchell made this morning, and I think it was in answer to one of our questions, I'm not sure whose, was that what is important in a case such as this, where there has been material, deliberate non-disclosure, is that either the person who's the victim of the non-disclosure, if the judge is going to say, but it makes no difference, or the person who has been responsible for the non-disclosure, if the judge is going to say it does make a difference, should know exactly why it does.
Yeah, yes.
Do you agree with that?
I do agree with that, yes.
Now, one of the things that Mr. Mitchell says is that is not clear from Sir Jonathan's judgment, because although he repeats the facts, he doesn't go into the necessary evaluative process sufficiently well as required by Kingdon, but more importantly as required by Sharland, that was decided after Kingdon.
Mm.
So what do you say about that?
Well, I don't agree that he doesn't do that sufficiently.
No, but do you agree, we may agree with you, we may disagree with you, but do you agree with the general proposition that Mr. Mitchell puts forward, that this unfortunate situation has got to be properly and demonstrably aired in any judgment after set aside, in order that it does put an end to matters? That the person who's been the victim of the non-disclosure can say, well, all right, I don't agree with the outcome, but I can see that you've really considered it. Or, on the other hand, that the person responsible for the non-disclosure can know that the judge hasn't gone overboard, if you like, in the assessment of turpitude.
The assessment, the last thing you say there, the assessment of turpitude, I think is synonymous with the idea of marital misconduct, which I'll come to.
Well, it may be, that's what we've been discussing, but I'm going to the terms of Kingdon.
Yes,
Do you think it's got to be amply demonstrated that it's been taken into account? That all of those features of Kingdon and Shawland have been put into the melting pot? Beyond, and this is a question of my Lady Justice Nicola Davies, the black and white, and she'll forgive me for being so crude as to her more elegant phraseology, the black and white pounds, shillings and pence.
Shawland, I don't think Shawland has anything to say about the way in which then the case should be determined afterwards. Indeed,
no, it doesn't.
Expresses...
It's the principle that Mr. Mitchell has sought to extract from Shawland, which may, to the majority of practitioners, have some resonance, especially to somebody who's in the Court of Appeal and their decision was overturned. But there we go.
I'm not trying to fence or be defensive or to be evasive about this. I want to try and answer your ladyship's question fully. So, in terms of whether or not a judge in Sir Jonathan's situation should to deal with something, or in his judgment, make it clear or make some sort of observation by reference to Shawland, I don't agree with that.
No.
Because I say that Shawland, all that Shawland says is that he's got enormous flexibility.
Yeah.
In terms of...
I'm not talking about tick box.
No.
Mr. Bishop, I'm not saying that every judge has got to say we've taken into account Shawland, we've taken into account Kingdon, we've taken into account H&H. I'll just put it once more and then we'll move on, because it could just be a thing that you will naturally cover. I'm not for the moment asking you to say that he did or he didn't. I might do in due course.
Okay.
But one of the general principles that we're asked to consider are the 4 issues in every case of non-disclosure that should be at the forefront of a judge's mind. Which is why I say, do you agree that the judge should be on high alert? And those 4 principles we've been through many times: impact upon the wife, in this case, but impact upon the person who suffered the non-disclosure. Integrity of court process, evaluation of turpitude, not just the fact of it, but fact of non-disclosure, but evaluation. And it might be that you want to say what should go into the evaluation process. And finally, that a person who has deliberately failed to disclose should not be allowed to benefit from his fraud. Now, that's a general principle. Do you agree that the court should take, first of all, those 4 principles into account?
I don't think I do agree with that completely. I think,
all right.
I think, my lady, what I say is that the court should arrive at a fair result, one which takes into account all the circumstances of the case and the Section 25 factors, that it should follow the guidance from Miller in terms of meeting the sharing principle or needs or compensation. If conduct is pleaded, of course, that has to be evaluated and dealt with. But is a case where there has been non-disclosure and then set aside something where the court then has to be alert to ensure that the perpetrator of the non-disclosure isn't benefiting from that non-disclosure? Yes, I don't disagree with that.
But you're saying that the alert should be as to the credibility of anything further said,
Yeah.
and that would be sufficient.
Yes, and there's not been any suggestion at the hearing before Sir Jonathan that there was material non-disclosure.
Can you? Neither husband or wife gave evidence before.
Sir Jonathan?
Yes,
yeah.
they did.
There was a 7-day hearing.
Yeah, 7 day.
7 days.
Yeah. Okay.
And Mrs. Hall gave evidence as well.
So, all right, yes, I'll come back to that in a moment.
The third reason, sorry, I must speed up, but the third reason why we say that Sir Jonathan not only was within his bound of discretion, but was right, was that his decision really does accord with the guidance from Kingdon. And what Kingdon is, to use a colloquialism, the judicial manifestation of the colloquialism, if it ain't broke, don't fix it.
You talking about Kingdon?
Kingdon. If a division, pursuant to an order, has achieved fairness under the sharing principle or the needs principle, as it may be, but save in one respect, then leave it be and deal only with what has not been dealt with. We say that that's the epitome of
Take us
proportionality.
to Kingdon where that appears, specifically in those, well, not specifically in those terms, but how you frame it.
Certainly.
That, if you're saying that Lord Justice Wilson was saying, if it's objectively fair, leave well alone.
It may be paragraph 37, about halfway down.
36 and 37 together. Notwithstanding the distinction drawn by Thorpe, I can well imagine, we go through the middle of the paragraph, the same multiplied. What I cannot accept is that the exercise will always have to be conducted again. The exercise certainly has to have been conducted, but it has been conducted. And the nature of the defect generated by the non-disclosure may or may not require the whole order to be set aside and the whole exercise to be conducted again. Take then the present case. In the exercise conducted ultimately by consent in 2005, what was the nature of the defect generated by the non-disclosure of the shares? The nature of the defect was the omission of a subparagraph of the order which provided for the wife to receive a lump sum, namely a subparagraph which provided for an extra deferred contingent element of her lump sum referable to the shares, which the husband hadn't disclosed. There is nothing wrong with the order dated the 18th of April 2005, save that it requires such an addition. There is no need to dismantle it. The need is to add to it. Indeed, in November 2006, the contingency arose, there is no further need to express the provision by way of a formula. The husband's net gain on the shares had been precisely quantified. Whatever would have been the appropriate percentage expressed in the formula can be translated into a specific sum.
Yes, well, that 37 is the present case. 36 says that it is not always necessary to do so.
Right.
But not what you've just said, Mr. Bishop, with respect, which was, if it's not broke, don't fix it. That's not what that paragraph says, is it?
Well, my lady, what is being advocated there is an assessment.
Well, what's been advocated in paragraph 37 is, if it's not broke, don't fix it, which is applicable to the facts of that case.
Yes.
But what he's saying, Lord Justice Wilson, forgive me, is saying in paragraph 36 is that it is, it's not always necessary to conduct it again.
No. Sorry, if I went beyond that, I didn't mean to.
No.
What I'm saying is, if the assessment is, in a case, that what exists there is fair, but just needs enlargement, if a judge is able to undertake that analysis, then just order the enlargement.
So if the judge, for example, in Sir Jonathan's position, looks backwards and sees from the judgments that the assessment has been carried out according to the principles, the applicable principles, then that's something that they can rely on.
Absolutely. And that's Mr. Justice Moylan in this case, and that's H&H, and that's Kingdon. And we say for all those reasons, Sir Jonathan was right to do that. And once that had been done and the defect had been cured, then the wife's sharing claims were at an end. And it's said that she has suffered by virtue of the husband's fraud. It's not the husband's frauds that have prevented her from securing more money. It's the fact that she's already shared that has prevented her from receiving any more money. So Jonathan,
Sorry, I don't follow that.
Apologies.
I mean, in one sense, it's true. It's not the point, is it?
The point is that it said, well, she's been kept out of her full award for a long period of time as a result of the husband's frauds. That's incorrect. The reason she hasn't received any more money is because of what she's already had.
I thought it was a broader point that the delay in itself is pernicious. Obviously there may be a financial. Am I wrong about that?
Well, I don't quite know, my lady, because Mr. Mitchell talks about the disadvantage of the delay in this case. But in circumstances where this wife has manifestly received her entire sharing entitlement and did that in 2016, then the delay between 2016 and today is not a delay which can be characterised as keeping her out of any money.
The theme, and you may be right, you may be wrong, but it's all about money. That's it.
Well, that's what the hearing is about the fair division of the fruits of the partnership.
And it's got nothing to do with fraud or anything like that. It's just got to do.
Well, the fraud.
We'll get back to your early point where you say that's passed because that's what's led to the rehearing.
Yeah, it is. It is.
And we've had that debate.
Well, I think that what's happened is that the wife has thought that she need do no more than just repeat the word fraud and fraudster time and time again in order to generate an entitlement to more money.
I think, Mr. Bishop, that's an unfair representation of Mr. Mitchell and Mr. Webster's points. It's not just fraud means penalty or fraud means more money, thank you very much. It's the impact of the fraud means that this must be taken into account, and it's not been. Well, I think it's a bit of an unfair representation.
Very well, in which case I withdraw it. But I ask this, how has the impact of the fraud, that's a rhetorical question, how has the impact of the fraud not been taken into account in this case? Or what impact should the fraud independently have over and above the determination of what these parties were entitled to under the sharing principle?
So does that take us into conduct?
It does.
Right.
And the authorities that we provided to you. But there are, I mean, I'll dash through them. It could be that. So,
is this an agreed selection? Because
we sent it at 120. I mean, I
yes,
commend ourselves.
There are many. It's an agreed collection.
Well, Mary, I was most grateful to my learned friends for extracting these principles. I don't think we seek to supplement them at all, and we'll make our points at the appropriate moment.
Yes.
Thank you.
So
Gary,
thank you, Mr. Bishop.
With your words ringing my ears,
And thank you,
make
Mr.
sure that there aren't any unhelpful ones that we were missing out, of course. There are 3 points about fraud or conduct, really, before I come to these authorities. The first is that it is repeatedly said by the judges in these cases that conduct should not be used to impose a penalty for moral misbehaviour. That's thing one. Thing two is there are 3, potentially 4 recognised categories of relevant conduct, and the only one into which the fraud in this case fits is litigation misconduct. And thirdly, the litigation misconduct, it's clear, should be dealt with by way of costs alone. So on that basis, it is my submission, it's not possible to see how a finding of conduct in this case could have affected Sir Jonathan's determination. We may look quickly at these authorities. The first is Akintona. I am going to scurry through these with your ladyship's permission. The conduct there, if you see in the head note, 6 lines down, at trial, the wife presented a case that was deliberately false in order to improve her prospects of obtaining the order. So that's the conduct that was being dealt with there by Lord Justice Thorpe and Lord Justice and Morland. And then if you go on, please, to paragraph 12. The second point taken, that's in the appeal, is that the judge failed to reflect in his judgment the gross misconduct of the proceedings by the mother. Mr. Twomey submits that authority shows that where one party is guilty of litigation misconduct, that will be reflected ordinarily in discretionary decisions as to costs and unusually in the division of assets between the parties. Here the judge seemingly accepted dishonesty as being nothing but part of the litigation history. He accepted her third and fourth appellations without seeming misgiving, and accordingly imposed no penalty on her in any way for her wrongdoing. Seems to me that in a situation like this, the judge must certainly not adopt a punitive campaign against the transgressor. There is, in my judgment, no evidence that the discharge fell into error. In my opinion, the proper approach at the hearing of the appeal was to treat the non's evidence with proper caution, not to accept a statement unless transparent or corroborated. The next authority is Ezer. I should say both Akintola and Ezer were before Sir Jonathan. From the head note, 6 lines down again. However, during proceedings, the judge found the husband had forged the wife's signature on a remortgage application form. The wife was awarded all the private assets. And again, Lord Justice Thorpe, dealing with that in paragraph 20, said, in circumstances like this, a safe and orthodox approach is to make an assessment of the lump sum, having regard to all the Section 25 criteria, and then to make a distinct cost order that marks the litigation misconduct of one party and quantifies it in a reasoned manner. Seems to me that the order made by the judge, unfortunately, impossible to support as a matter of principle, for absence of clear reasoning. My lady, on to H and H. The conduct there, you see again, weirdly, on the 6th line, the husband was currently serving a sentence of 12 years imprisonment for the attack, having been convicted of an attempt to murder the wife. And the relevant paragraph is in paragraph 44, where Mr. Justice Coleridge stated, how is the court to have regard to his conduct in a meaningful way? I agree with Miss Jacklin that the court should not be punitive or confiscatory for its own sake. I therefore consider that the proper way to have regard to the conduct is as a potentially magnifying factor when considering the wife's position under the other subsections and criteria. The glass through which the other facts are considered, it places her needs, as I judge them, as a much higher priority to those of the husband, because the situation the wife now finds herself in is in a very real way his fault. And there was a assessment of needs that gave the wife much more generous provision than the husband.
Well, his attack had left her physically disabled.
And that's another factor which we see in these cases, which is it's looking for a financial consequence in relation to the conduct and addressing that rather than looking at the degree of moral turpitude in relation to the behaviour itself.
Well, is that right, Mr. Bishop? Because in this case, Mr. Justice Coleridge was saying the wife now has ill health, which is one of the factors that the court must consider under Section 25.
Yeah.
And the reason for that disability or ill health is the husband's acts in trying to kill her.
Yeah.
So it's not just the effect of his attack, it's the consequence of his attack. So isn't Mr. Justice Coleridge saying it's not just to be seen in terms of creating the the situation, but to have in some manner, weight given to the fact that his responsibility in causing those injuries must be reflected.
Well, in a situation of marital misconduct, possibly, but really, I say the correct...
Well, actually, Mr. Bishop, I think anybody who attempts to murder anybody shouldn't have a distinction whether it's their partner or otherwise.
Well, I'm not trying to minimise the conduct in that case.
But you say that in this case, Mr. Justice Coleridge only looked at the impact of what had happened.
Yeah,
and that was correct. That's what you're saying.
That is what I'm saying.
Yeah,
and
okay.
That's picked up in some of the guidance offered in the last case, O and G,
Right.
which is a decision of Mr. Justice Mostyn. And your ladyship knows that Mr. Justice Mostyn sometimes surveys the law very helpfully and comprehensively in his decision. If you just go to the head note, the conduct, number one, conduct is relevant in financial remedy cases in 4 distinct situations. First, there is gross and obvious personal misconduct meted out by one party against the other. This will only be taken into account in very rare circumstances and will only be reflected where there is a financial consequence to its impact. That was the point I was making just a moment ago. This can extend to economic misconduct if one party economically oppresses the other for selfish or malicious reasons, provided the high standard of inequitable as met may be reflected in the substantive law. Secondly, there's add back. In this case, that's when there's been a dissipation and they decide to add. Thirdly, there is litigation misconduct. Where proved, this should be severely penalised in costs, although it is very difficult to conceive of any circumstances where litigation misconduct should affect the substantive disposition. And fourthly, there is the evidential technique of drawing adverse inferences to the existence of assets from a party's conduct and failing to give full and frank disclosure. And then just dealing briefly, if I may, with the said there. Paragraph 34.
Yeah.
Conduct rears its head in financial remedies cases in 4 distinct scenarios.
So this is just where the head note is derived from.
That is, but there was another passage there. I'll just ask Mr. Sear if he can find it. Yeah, if you wouldn't mind going to paragraph 71.
Yeah.
I think that's right. '71, please. Time was when the court exercised its discretion in relation to ancillary relief. It formed first and foremost a moral judgment. Therefore, in that case, Sterling Court Justice held that the exercise of every discretion which is vested in the divorce court, the court should endeavour to promote virtue and morality and to discourage vice and immorality. The moral judgment that was formed in those days was almost always about sex. I have not located any judgment in the old era where financial dishonesty was independently penalised. But times have changed. The financial remedy court is no longer a court of morals. Conduct should be taken into account not only where it is inequitable to disregard, but only where its impact is financially measurable. It is unprincipled for the court to stick a finger in the air and arbitrarily to find...
These are very broad statements, aren't they?
Yes, but they reflect, in my submission, the correct approach to looking at conduct.
And is that those words, not only where it is, should be taken into account, not only where it is inequitable to disregard, are those reflecting the words of section 25?
Yes. Mm-hmm. But it's the point there that only where its impact is financially measured.
And is what you're saying this, that in this case, the impact
saying
was measured and reflected in the order of the court.
I am saying that. I'm saying that the only conduct that my client's non-disclosure could fall into is litigation misconduct, for which he was severely penalised on 2 occasions. And that the delay that was brought about by virtue of the double rehearing in this case is not something that it's correct to say was to the prejudice of this wife in circumstances where we say she had already received her full share of the assets by 2016. Just to finish on this set of my submissions, the judge had the discretion to decide what weight to attach to the facts and circumstances of this case, including the 2010 division. He had the discretion as to what was the right approach to adopt under Charlotte, whether it was necessary and fair in this case for there to be a complete rerun at current values, or whether or not to leave things intact that were fair. And he had a discretion to decide the extent to which the earlier divisions in 2010 and 2016 had completely shared the fruits of this partnership. And he exercised that discretion entirely reasonably and correctly, and in line with Kingdom, in line with H&H, and in line with how the case had been dealt with by Mr. Justice Moylan. Now, turning to the grounds.
Before you do, Sir Jonathan Cohen decided that this wasn't an all or nothing case.
Well, quite.
And therefore he went on to say the sharing principle didn't take into account the unanticipated burden upon the wife of the children's dependence upon her.
Not quite right, my lady. The way in which there had been an unanticipated burden in respect of the children's upbringing from 2010, he reflected by way of allowing an enhancement to the wife's needs, a payment in relation to her needs.
The 1.1 million.
The 1.1 million.
So that was capitalised.
It was capitalised. It was, and I'll come and develop this, I'm happy to deal with it now.
So
it was,
yes, do just for the moment, please, and you don't have to develop it beyond this. So on that basis alone, isn't the wife entitled to say, well, I didn't get a fair division in 2010 and 2016 because the judge has already said, by reference to the extra 1.2 million, that I didn't?
Well, no, she got a fair, sorry to...
No, please,
She
it's
got
a genuine
her
question.
fair share,
Yes,
under the sharing principle,
yes,
she got her fair share.
yes,
And there was no more sharing to be done.
yes.
because
So
we
how did the judge go about then
So
saying...
then the judge said, I'm going to make an award in relation to needs. I find that this wife comes before me and she has some needs that need to be met, and I'm going to make an order
in
for that.
2022.
And that's in 2022.
So in 2022, he's prepared to take the up-to-date position in relation to needs.
Yes. And indeed, I think that it might, well, it
So-
might have been a difficult, sorry, Melody.
No, please go on.
It might have been a difficult proposition for me to say you could ignore her needs, because I accept, of course, that the judge had to take into account all factors under Section 25 of the Matrimonial Causes Act, which include needs.
Once he'd reopened.
And so he had to...
That was a question. Once he'd reopened, he had to go into Section
Well,
25.
it was restored...
It's a question.
Yeah.
Once he'd reopened, it was necessary for him to go into Section 25
Absolutely.
factors. Yeah, that was
Yeah.
the question.
I beg your pardon. So sorry to interrupt you as well. Absolutely, he had to take into consideration Section 25. And he did so. And when considering sharing, he took into account, I won't repeat this again, but he took into account everything
I
that
just
happened.
wanted to know the basis of which you say he could distinguish between the sharing and the needs in 2022 on a different basis to that which you're putting forward now, which is that he should be looking at 2016 and saying, that's it. Because otherwise what you're seeking to do is to reopen the events by virtue of incidents that have occurred subsequently that would not have been taken into account if this court was not seized of the matter by reason of the reopening by virtue of non-disclosure. That's all I'm interested in.
Yes, I beg your pardon. And what he does, and it's very clear from the judgment, is that because of what he said was the wife having done a greater share, an unanticipated great share in relation to the children, he said, I'm going to reflect that in my assessment of her needs. Now, the assessment of the wife's needs was, it's fair to say, extremely generous. The approach is very generous because the wife had articulated no needs case at all, not even in the alternative. She said, I'm entitled to a share of CBA.
Well, we've seen how the judge puts it, that she hadn't made the share, but he thought it was right to proceed, despite your arguments to the contrary.
So I said, but don't forget, please, that the wife had £14 million.
Yeah, I know, but we're going off course here. It's
Very well.
my fault, I'm sure. I just wanted to know what you thought about the principle of the judge who's saying that everything that was done in 2016 at the latest was fair division, and that would normally bring an end to all proceedings as between the wife and the husband regarding financial matters, in accordance with normal practice. And yet the judge, Sir Jonathan, in this case, having determined that everything was fair back in 2016 and looked at from that prism, was everything bought as it were right? He said, yes, it was in terms of the company. Yes, it was by the 2016 edition, by the edition. But now, even though those two aspects of non-disclosure have no bearing upon the wife's unanticipated needs, I'm going to go ahead and make an order. I mean, how do you square that with what you're saying to us?
There's no inconsistency, my lady, with respect.
Right. So tell us why not.
Because the judge had to decide at that hearing what the wife was entitled to under the sharing principle and what her needs required. He also had to consider compensation, but obviously didn't arise in this case. He had to do that, as all financial remedies judges do. And he considered what she was entitled to under the sharing principle.
As at 2022.
As at 2022, and concluded rightly that she was entitled to nothing because she had had her share in 2010 and 2016.
So,
okay? So
why was it fair for him to go on and say, but that's a fair division, and that's how, as Mr. Mitchell concedes, these cases of high worth are dealt with? It's not needs, it's sharing.
Well,
but he goes on in 2022 to say, regardless that I pulled down the guillotine in 2016 as regards the company valuation back in 2010, I can now say that all of the things that have happened since then entitle me to go forward on a needs basis.
That's entirely legitimate, because what he did was he was looking at the wife's sharing claim and found that that had been satisfied. That was one part of his statutory duty and he discharged it. So on that basis, the wife were to receive zero. And he looked at the wife's needs claim. And her needs claim, assessed in 2022, he found, I submit generously, that fell short by £1.1 million.
So you're saying that this was not a case which could have been dealt with by the sharing principle once and for all?
Well, it was did say that the wife having received her share amounting to 14 million, that was sufficient to meet
I know
needs
that
as well.
was your argument below, and
Yeah.
I'm asking you if you say, although you haven't put in a respondent's notice, that actually he should not have done that, because the assessment, once he'd found out, once he'd siloed 2010, 2016, he should not have embarked upon a, well, in actual fact, I'm now going to go and consider your needs, even though in normal circumstances, given the capital share you got, you would be expected to take care of those yourself.
But he was entitled to do that within his band of discretion.
Right. So
He was definitely entitled to do
right,
that.
Okay.
I didn't agree with it, but he was entitled to do that.
Can you help me? It'll be my fault, but just as a matter of logic, how does the emotional and physical unanticipated exclusive contribution of the wife towards the children's care come into needs?
Well,
as a matter of logic.
Well, if you were going to allow that to impact on sharing, my lady, you would have to come to a view as to overall unmatched contribution.
Exactly, I understand. I
Yeah.
can see the link to sharing.
Yeah.
Just as a matter of logic, what is the link between the wife's contribution exclusively, alone, parenting for the 3 children? How does that, the past,
Yeah.
how does that come into needs?
Because other factors can inform, other Section 25 factors can inform the way in which needs are assessed, the generosity or the parsimony of which. And so we know, for instance, a long marriage needs are going to be assessed more generously. That's allowing the duration of the marriage to have an impact on needs. We know, like in the murder case, or the attempted murder case, that conduct can have an impact on needs. We know from other cases where if needs are all being met out of inherited wealth, that can lead to a more conservative assessment. So the assessment of needs is one that can import consideration of the other Section 25, and that's what the judge did in this case.
And you're quite happy that because the case was properly reopened, although I know that you challenged that, but properly reopened, that the judge could proceed on 2022 information regarding to that.
In relation to needs?
Yes.
Yes.
Okay.
Yeah. I don't think you're setting a trap for me, my lady. But
I am genuinely asking questions, Mr. Bishop, to understand your case.
my case is that I don't think this wife did have much of a needs claim before Sir Jonathan because of everything, etc., etc. He disagreed with my submissions on that, and he found that looking at her situation in 2022, even though this was 12 or 13 years after separation, she'd be living with her cohabitee the whole of that time.
Well, I think you're going into merits now, and I
Well,
don't want to go
you know,
into merits, thank you.
he said,
I just wanted to know the fact that you didn't put in a respondent's notice. I think you've explained, as you said, that he was entitled to do this.
Absolutely.
And you don't take issue, now he did do it. You'd rather he didn't, but you don't take issue with the manner in which he went about it.
No, I don't.
Right.
No, I don't.
Okay.
I mean, that
all we
was within his discretion what he felt, and he allowed the impact, and to some extent, I think he talks about a bit of turpitude in there as well. He thinks that comes into it somewhere. And so, what we do take issue with is the suggestion that, having found that the wife had done a greater share of the sole share of the caring over that 12-year period, that in some way should have been brought into consideration in relation to sharing in a case where his explicit finding was that her sharing claims had been completely satisfied by the 2010 and 2016. And I would just like to say also that it wasn't a disputed fact before Sir Jonathan. My client made a substantial contribution to these boys over the past 12 years by way of his financial provision. He paid child maintenance, he paid school fees. He'd enhanced the value of the assets within the trust.
We're not going to have those factors at the front of our mind when we're deciding this case.
Understood.
But I understand it's important that you should make it clear that the father has got an alternative case to that which was put before.
So what, turning to the grounds, I'll try and do this quite quickly. Well, they say, my own friends say that he was, by ground one, that the judge was wrong to take into account the 2010 division. But we say that this is and has been misconceived. What he was able to do and did was to look at those divisions. The actual divisions, rather than the orders that made provision for them, but the actual divisions, and decide whether the fruits of the partnership had been divided. And that's what he did, and he did it in a way that can't be criticised and is in line with authority that says that the search is for objective fairness. The counterfactual illustration put forward by my learned friends, oh, well, what if this is a case there just been heard in 2022 on the current figures, albeit the parties are separated? That misses out the key facts. The key facts are the division that took place in 2010 and the addition that took place in 2016. So it's a completely false comparison. It's quite wrong to suggest that this wife's fair hearing rights were transgressed at the hearing on the 22nd of January. They had been transgressed before, and that's what led to the set-aside in November 2019. But by the time the matter was before Sir Jonathan Cohen, all facts were known, everything had been updated. She had every opportunity to put all of her arguments on the basis of complete disclosure and understanding of the full history, and her argument was, I should be treated as being able to share in today's value of CBA, and the judge rejected that argument.
Yeah. The one thing I said I'd come back to, Mr. Bishop, is dealt with appropriately at this stage, I think. In the 7-day hearing, we have no transcript of the hearings, thank goodness. But was the husband cross-examined on behalf of the wife regarding the manner in which he failed to disclose the offer for 25% of the shares and the reason why he had done so?
He was cross-examined about that before Mr. Justice Holman.
No, I'm talking about in front of Sir Jonathan Cohen, which is why I asked whether the parties gave evidence before him.
Not specifically. He was cross-examined a lot about his past dishonesty and his whether he felt contrite about that. Whether he was asked at that hearing about the specific sequence of events leading up to the hand down in November 2016. I don't think he was cross-examined about that at that hearing.
Right, so it may be that... So at the time of the hearing before Sir Jonathan Cohen, your recall is that the cross-examination was about generally dishonesty or going through the chronology of when the offers had been received, what proceedings were going ahead at that stage. Was anything done in that light?
May I just ask Mr.
Yes,
Seeley?
of course.
We don't believe he was.
No, okay.
My lady, if it assists, I think the recollection on this side of the case is the same. We don't think that cross-examination took place.
Excuse me on that. I mean, my client asked me to just to remind your ladyship that the basis of the non-disclosure finding found by Mr. Justice Holman was that my client's company had made the offer, and there had been it wasn't an offer received for that value. It was the offer that my client had made and failed to disclose, and the response from the counterparty, which had not been completely negative. I mean, I'm not obviously seeking to go behind Mr. Justice Holman's findings that this was material non-disclosure, but it's all set out in his judgment.
So, Mr. Justice Holman determined that the husband's dishonesty was in not revealing that the negotiations were ongoing.
Correct. That there'd been an ongoing dialogue.
And so the 25% share in the company for 25 million, that was not a firm offer.
Absolutely not. I mean, I don't want to go into this in too much detail because there are
And
findings.
so what was the relevance then of this surfacing just before the evening before the order made?
If I might be allowed 2 minutes on this, the deal that led to 25% for 25 million
Yes.
was finalised in January 2018. That is 14 months after the hand down of judgment. And what we submitted to Mr. Justice Holman, rejected, but was submitted, was that up until it was finalised, there was no certainty that that was going to happen. Moreover, there was no certainty that when my client made an offer, I will sell to a special purchaser, I will sell 25% for 25 million. There was no certainty that that was going to be accepted. But nevertheless, Mr. Justice Holman found that all of that, the discussions and the fact that my client was making that offer, should have been disclosed to Mr. Justice Moylan, and the failure to do so was fraudulent on my client's part.
So what was it on the evening before Mr. Justice Moylan gave judgment that Mr. Justice Holman took exception to?
If you would kindly go to Supplementary Medal 93.
Yeah.
There's the letter. There's the email. From my client's company. From my client's company. Oh, sorry, from Grant Thornton on behalf of my client.
So we look at 43. By the afternoon of Wednesday 23rd, 2016, the hand down and the hearing before Moylan J had concluded. Miss Stone, QC, on behalf of the wife, submits that the timing of this email is no coincidence, but reflects the belief of the husband that he can go safely to the next stage now that the judgment had been delivered. I'm not willing to accept that particular submission, given that the meeting had taken place in Yeovil on Monday 21st November and the proposal sent to X on the afternoon of Tuesday 22nd November. It seems to be entirely natural that the husband and his staff should wait until they knew they would be meeting the following day in Jersey. I do not attach significance to the precise timing of the email. So what does he then say? Paragraph 48. The question can perhaps be tested in this way. In my view, if Mr. Amos, QC, and Mr. Sear, or any lawyer experienced in the field of matrimonial financial proceedings, had in fact seen or been told about the email on 22nd November and the antecedent contacts, they would unquestionably and unhesitatingly have said that it must be disclosed. If the husband had maintained an instruction to them not to do so, they would have been bound to withdraw forthwith from the case. So the non-disclosure was of the continuing negotiations.
And specifically the offer that had been made.
Yes.
And we see the offers and the emails summarised 39 onwards.
Correct.
And the findings made in relation to the timing and all the rest of it, and the response to the offeree, of the offeree, to the offer made.
Yeah, but there certainly wasn't an agreement in relation to
No.
this.
So was the husband cross-examined about the emails and what his motivation was for not disclosing to his own advisors the fact that these are ongoing? Was he or not?
Before Sir Jonathan Cohen, no,
Yeah,
he was not. I'm pretty sure of that from my recollection.
Thank you.
I think I've addressed you why I say, at some length, why I say they're wrong to say that Sir Jonathan was incorrect or not.
For myself, I think you have, Mr. Bishop. You've done a global response to the grounds,
Yeah.
but you seem to be saying we say that the judgment below should be upheld for the reasons given in the judgment.
Yes.
And that they come within a reasonable band. And in fact, we would go further and say that they're right,
Yes.
but we don't need to. All we've got to say is reasonable band of decision, end of.
That is my position. Can I just deal with Kingdom
Yes, please.
specifically? And that is, first of all, the list of rules that is proposed as to when and where Kingdom should be permissible to be invoked. We say this is absolutely at odds with what Baroness Hale says in Charlotte, which is the trial judge shall decide with enormous flexibility about when and how to conduct the rehearing. You remember from Charlotte in the Supreme Court, of course, the phrase enormous flexibility in relation to a rehearing to fit the case, the specific endorsement of Kingdom, and the absence of any rules about how and when Kingdom should be raised or pursued. That approach to be followed. Indeed, a collection of rules, such as those suggested by Leonard Friend, is the antithesis of the enormous flexibility that is mandated by the Supreme Court. Whether or not to adopt the Kingdom approach is a matter of discretion. That is clear from Kingdom itself, and the reference for that is 38, para 38A on page 103. And also conceded by my own friends in their skeleton at paragraph 18.
Well, I think it's been further conceded today.
Which is core 82. So Jonathan had the discretion about whether to pursue a Kingdom approach. And that's a discretion that he exercised, we say, reasonably. But what is said is that, well, this court should pronounce that a husband in my client's position should be forbidden from proposing Kingdom. And I think that the court, notwithstanding its enormous flexibility and its discretion, should be forbidden from adopting the Kingdom approach if it is for the benefit of someone who has been guilty of non-disclosure. You see, that just simply can't be right, because that is to prescribe how a judge should exercise his discretion and how a judge should undertake the Section 25 exercise. Now, there has been colossal emphasis laid on the phrase degree of turpitude, which is included within Kingdom on page 103 by way of a quote from Lord Justice Thorpe in Williams and Lindsay. Accordingly, nothing that follows is to be understood to apply to taint cases where the procedure and adjudication may need to reflect the degree of turpitude of the party responsible for the taint. But you can see immediately from paragraph 36 that the judge is interested really in whether or not the distinction between barter cases and material non-disclosure cases is one which always exists. Degree of turpitude affecting the procedure on a rehearing is pretty easy to understand. So if a husband comes along and says, I would like you to adopt this particular procedure, the judge may well say, well, you forfeited the right to dictate that. To say, for instance, there should only be summary disclosure because of your earlier lies, where there's going to be a full process of investigation of value. And so one can see that. A degree of turpitude affecting adjudication. Well, it's possible that a non-discloser may have their needs assessed more conservatively. Or there might be an add back in relation to a large amount of costs that have been spent in relation to a rehearing or investigation of matters relating to it. But beyond that, my learned friends cannot use this reference there in Kingdom to seek to rewrite the rules that have been developed in relation to conduct, which we looked at a little while ago. And you'll be aware that there's nothing in their skeleton argument dealing with conduct and saying that it's not one of their grounds. He failed properly to address conduct. And so we say that be wary of this emphasis on degree of turpitude. That's not the point of Kingdom. The point of Kingdom is that a judge may, in his or her discretion, decide that what has been done in the past should be left intact, subject to addition if necessary. We say that, exercising his discretion, Sir Jonathan Cohen was entitled, on the facts of this case, to adopt this approach. It's said in my learned friend Skeleton, paragraph 22, which is at core 84, that it's wrong to characterise the payments that were made in 2010 as being in settlement of the wife's claims against the company, or in respect of an interest in the company. With respect to them, this just doesn't make any sense. She got cash and property worth 7.25 million. He retained the company. This was within a process of division of assets on divorce. What other interpretation can there be that any notional interest the wife has in this matrimonial asset of the company was exchanged for cash in 2010? That's the only logical interpretation of what happened. And again, as I say, they're wrong to say, in paragraph 23 of their skeleton, that the judge was not entitled to look at the counterfactual situation of what would be the case if CBA had gone bust. CBAs had gone bust, the husband wouldn't be able to go back and say to the wife, well, I'd like some of that £7.25 million back, please. Because the sharing took place, and once it had taken place, there was no justification to revisit it. And that was part of the fairness of the division, that he was left with a risk and she had the security of cash, £4 million, and £3.25 million property. What is said in ground, I've dealt with ground 4. What is said in ground 5 is that the wife should have been allowed to share in the assets as at 2022 because the delay in finalisation since 2010 had been husband's fault. But again, with respect, this adds nothing because it all stands or falls on the assessment of whether or not it was reasonable and fair and within his discretion, for Sir Jonathan Cohen, to decide that the wife had already shared fairly in the value of CBA. And if she had shared value fairly in the value of CBA, then it was that which was the barrier to her getting any more. So we say that this decision is unassailable. It's undoubtedly within the boundary of his decision. And we say it was a fair and reasonable assessment of objective fairness of earlier divisions. The fact that there has been a long period since the 2010 division raises another factor in relation to post-separation accrual. But I accept, of course, that Sir Jonathan doesn't deal with this in his judgment at all. We advanced it very fully in front of him at the hearing, both written and oral submissions, but his judgment doesn't touch it. And that's because he didn't need to go there. Having decided that there'd already been complete fair sharing in relation to the assets, he didn't need to consider post-separation accrual. But we say, were this matter to this appeal to be allowed and the matter to be remitted, another judge will have to grapple with post-separation accrual. Because as Mr. Justice Moylan said, at paragraph 96 of his judgment, that I would have to make considerable allowance for the fact that the current values of CBA reflect the husband's work over the course of the last 6 years, for which read 12 years.
Can we have the reference?
Yeah, beg your
our
pardon.
notes?
64 in the supplemental bundle.
Paragraph.
96, my lady.
Thank you. Yep.
Further, if I was to undertake the discretionary exercise by reference to the current value of the resources, which he doesn't do, I would have to make considerable allowance for the fact that the current values of CBA reflect the husband's work over the course of the last 6 years. Indeed, it would be easy to conclude that the difference between the values given for 2010 and the current values are not the product of marital endeavour. The husband has not been trading or gambling with the wife's share because the resources were disclosed, including the husband's interest in the companies, because the resources as disclosed, including the husband's interest in the companies, were shared in 2010. And so the question of the intervening period is one that would have to be considered in the light of the post-separation accrual identified there. It's also referred to in the decision of Mr. Justice Holman. But I don't think we need to look at that.
Do you want to give us a reference?
Yeah, well, why don't we look at it, in fact? Sorry, I mean...
Well, I'm quite happy for you to give me a reference, given the time.
Yeah, the reference is supplemental bundle 100, paragraph 71.
Thank you.
My lady, the law and relevant facts in relation to post-separation accrual are set out in our skeleton at paragraphs 51 to 62, which is on the core, starting on page core 108.
Thank you.
My lady, to misquote Ian Fleming, you only share once. And this wife had her share, and it was analysed carefully, and it was objectively fair. Through my client's dishonest non-disclosure, this case has been reheard twice, and my client has paid a heavy price for that in terms of indemnity cost orders and delay as well. None of these submissions seek to diminish the significance of his litigation misconduct, which was found by Moore J, Holman J, and which led to those consequences that I've recognised.
Okay.
But the case then came back, and when it came back on rehearing, my client was entitled to a fair hearing just as much as the wife. And what that meant was that the judge would apply principles in assessing what the parties' rights were under the sharing principle or the needs principle. And as I say, the fair sharing in 2010-2016 satisfied and determined the wife sharing claim as found not by one but by two specialist High Court judges. And those were all the points I wanted to make, unless there are other things that you would like me to deal with.
But again, I've asked as we've gone through, Mr.
Yeah.
Bishop. But no,
No, thank you.
Yeah, thank you.
no, thank you very much indeed.
Thank you.
So, Mr. Sear, do you follow? So, Mr. Mitchell.
Yes. Before I carry on, you did indicate this morning that you might want a short break this afternoon. Is now a suitable moment?
You might.
Yes. Yes.
Of course. Space of time, but let me move it for you. Not a problem. Just outside. I just wanted to put your side. I've got the gist of what 2 cents. Just wait. I've got the gist of what's 2 cents. I've got. Yeah, no, Frank. Right. You will. Keep them up. Don't see it on your picture. Right. Know what's happening. We're following the news. Why 11-year-old. Remember it was when she was all held up before the turn at Taliban. just ask you something really. Want me to get it wrong? 40.
Do what you like, Brian.
Thank you very much.
Yes, we have seen the news, yes. Yes, and we've all been rather understated about that, aren't we? Jaw-dropping piece of news at lunchtime.
What a job was it when she was... someone was just taking a picture of it from when she first became... I was the district reporter in Eastern England. And she became MP for whatever...
South Norfolk, isn't she?
She got called up before the local Conservative Association to explain why she'd had an affair.
Oh, yes, I forgot she'd had an affair with
Mark Field.
Mark Fields, yes.
No. The Lynn News have got a picture on their website in a media scrum.
They were.
She was very strange. She wouldn't answer any questions. No. She's really young. She got last week.
She is very strange, I think.
Well.
What do you think? Already? Yes, yes.
They've done Skelly's
We've not done a Skelly on. Yes, we have.
Yeah.
What time? Slightly irritating. I've got nothing in my inbox after 2:26. Thanks.
Right. Thank you, Mr. Mitchell.
Ladies, yes. A number of points to be made, which I will try to deal with briefly. Now, the first point, the overriding point, is that although you've been taken repeatedly to the judgment of Mr. Justice Moylan, we've already demonstrated in my submission from looking at the relevant passages in Carr that it has no relevance, legal relevance, as a judgment. That is those are the words of Lord Sumption in that case. Now, having said that, my page is open on page 64 of the supplementary bundle, paragraph 96 of the judgment of Mr. Justice Moylan you were taken to a moment ago by my learned friend. And that seems to me to encapsulate why my client feels a sense of injustice and why she has come back to the court and now to this court. So I'm back, in a sense, to...
Did you say 56?
664, paragraph 96.
64.
Page 64, paragraph 96. Yes, of the supplemental bundle, lady. I'm sorry if I didn't make that clear at the beginning.
Yes.
So that's the middle of Mr. Justice Moylan's judgment, which my learned friend took you to a moment ago. Consider the steps in this way, if you will. So my client negotiates an agreement with her husband, and before it's turned into an order, she discovers that there was a lie told. Now, in those circumstances, that agreement would simply go into the bin, and the court, considering all of the factors, would apply no weight to it and would simply perform the exercise with a clean sheet. That has not happened to my client. So she discovers fraud. That fraud had been turned into an order. She applies to have the order set aside. Is she allowed a clean sheet hearing? No, she is not. Now, I've already made submissions about why, in actual
He
fact,
isn't allowed a clean sheet hearing by Mr. Justice
but
Moylan.
by either judge, and I'm going to come on to the reason I've got page 96 open is because it demonstrates the extent of the prejudice that my client suffered in the process.
You say page 96?
No, paragraph 96,
Yeah.
this page. So, had she been bringing her application for the first time, Mr. Justice Moylan would have had to consider the points that he raises in paragraph 96. He would have to have considered the discretionary exercise by reference to the current value of the resources. He would have had to hear arguments about departures from equality to reflect post-separation accrual on the one hand, and the other arguments that my client would have against that, the undivided share point, for instance, which he purports to deal with summarily, but which I have demonstrated is not accurate in this case. On the other hand, and then weigh up the reason for the delay. But he doesn't do that at all. He just says, oh, well, I think the agreement was fair enough, and so given that, I'm not going to trouble myself to perform that exercise. And it's very clearly set out there in paragraph 96 of the judgment that he doesn't think that he should have to do that. But in my submission, when one looks at the facts in that way, it is absolutely clear the unfairness that my client has suffered. And she suffered that because she was misled into saying, yes, I agree with this, when she was offered a financial proposal in 2010. And then because Mr. Justice Moylan was misled in 2016. And yet here we are in 2022 with the judge similarly declining to afford her the opportunity to have these arguments properly evaluated. And that demonstrates in my submission both the loss and, given my analysis of the likely way that the court would approach that exercise if it truly were a clean sheet, the extent to which the husband has benefited from his fraud.
So does this bring into play conduct?
Right, let me deal with the conduct points now. Excuse me just a second. I don't agree with my learned friend that conduct is a red herring.
Well, why didn't you raise it before in terms of authorities? And it was only when I was discussing with you the factor that turpitude would play in the award rather than procedure that you said, well, the court, as you quite rightly reminded me, that Section 25 does require conduct to be taken into account if it's inequitable to disregard it. But it was kind of the parry that you made.
The answer to your ladyship's question is because it seems to us on reflection that it is a point which should not be disregarded and which perhaps we should have raised for determination.
You should also put in those authorities, shouldn't you?
Yes, we probably should have done. Now, generally speaking, I think that lawyers who practice in the field of ancillary relief steer clear of conduct. The whole of the jurisprudence is to that effect. It is to discourage people from raising allegations of conduct in an area which is ripe for those allegations because inevitably there is acrimony between the couples when cases come to court. So the general policy is to discourage conduct, save in cases where the conduct is obvious and gross, or to use the word of the statute, where it would be inequitable for the court to disregard it. So I think for that reason, we did not analyse the case in those terms, and nor, I don't think, would I do so again if I was asked to consider this case, because actually we think that the issue of how we get to be where we are is more properly or conventionally considered by balancing the delay and the post-separation accrual that might have taken place through that period, and the arguments that the husband in this case would advance with the reason for the delay. That doesn't directly engage conduct.
Can I just ask, I mean, I've just by chance opened a page of my notebook. I was looking back at my notes this morning, and I've written moral turpitude of the highest order. Now, I know those are your words.
Yes, they are.
For myself, I have difficulty understanding how you say that isn't conduct.
Well, I have used the words moral turpitude because they're used by Lord Justice Wilson. In fact, they're not. They're cited from the earlier case by Lord Justice Thorpe, the case of which the name of which escapes me, but it's cited with approval in Kingdon, and Lord Justice Thorpe uses the expression turpitude. He is talking about that not in the context of conduct, but in the context of procedural fairness. It seems to us. But the discussion then arose in this court this morning about how one might deal with the consequences of the delay and whether conduct is a relevant way to look at it. And the reason that I'm now saying I don't think it's a red herring is because it seems to me that the answer is supplied by Mr. Justice Coleridge in his judgment in H&H. So can I invite you to look at page 996 of that report? It's paragraph 30. It's the end of that paragraph. So the first point to make is he says that the authorities are fact-specific, so fact-specific that they are very little real guidance in the end. Section 25 rules the day. But then at paragraph 44, he says, conduct is the glass through which the other factors are considered. So it's right to say that one does not look to conduct to penalise a person, subject to an exception I'm about to give in a moment. But it seems to us that where the conduct complained of is fraud, it is possible to look at arguments that in other cases would not carry very much weight in a different way.
And that's what the judge did on needs.
Yes, and I say if a court faced with the facts of this case is asked to evaluate the weight of the husband's post-separation accrual argument, it could evaluate that argument through the lens of his misconduct. Now, we hadn't expressed it in the terms of conduct, but our skeleton argument is quite clear, isn't it? That one can consider the reason for the delay. And
yes, it is, but Mr. Bishop is saying to us, well, look, there are 4 clear categories that are recognised in the authorities where misconduct will be a force to be reckoned with. Yeah. And this morning you'll recall, Mr. Mitchell, that I said to you, so are you saying, this is what came into being as conduct, are you saying that the fact of the reason for the delay in this case, taking the facts of this case, say 12 years delay in this case, is all because of 2 frauds? And I asked you specifically, so do you say that when the court comes to consider the reason for the delay, as it would do, as you say, if Mrs. Goddard-Watts had put in her application of Form A in 2022, the court would then consider, why has she delayed so long?
Yes.
And she might say, as did Mrs. H and H, that, well, what happened was, I thought that we'd reached an amicable arrangement. We were on civil terms, and then all of a sudden I found out that the basis of my trust in my ex-husband had been shattered. Would that mean that she should then be entitled to get more, even if the award was fair? And you said, yes, it would, because of conduct.
Yes. Well, if I use that word in an incautious sense, then I apologise. What I mean is, yes, because of the reason for the delay. The reason for the delay is something that is not irrelevant, and indeed where it is fraud is something which the court should censure. Now, I was going to come on to Mr. Justice Mostyn's useful and I think largely uncontroversial summary in OG and AG, and perhaps we could just look at that now. It was on page, well, it's paragraph 72 of that report, over the page onto paragraph 73. I don't disagree. We don't disagree with Mr. Justice Mostyn, where he says it is unprincipled for the court to stick a finger in the air and arbitrarily to fine a party for what it regards as immoral conduct. But that's not what we're suggesting will happen here. We are suggesting nothing more than that this husband ought not to be able to rely upon earlier tainted distributions and should face the ordinary process of adjudication about how you divide assets, because that hasn't been possible prior to this, and that the court should heavily weigh the reason why it is adjudicating this matter 12 years on from separation against any argument the husband would otherwise have to retain what he will contend he's built up during that time.
But
now,
do you therefore agree that on the basis of your submission, if we were to be with you, then the one thing that you are not inviting us to do is to deprive Mr. Goddard-Watts of a fair trial and the ability to put the arguments that he'd put in relation to present-day valuation, post-separation accrual. You wouldn't do that.
of course we're not suggesting that that should
why
happen.
is it
but
that it's been suggested that we, as the Court of Appeal, could make an award, if we were to allow this appeal, of 13 million?
Well, the answer is because that award is entirely justifiable on the basis of the figures that were in front of Sir Jonathan Cohen.
But without with respect, the very arguments that you're saying should have been put, and that Mrs. Goddard-Watts should be entitled to put.
No, we have discounted it. So if you take a straight line increase in value, we have divided the matrimonial portion of the increase in value and say that we want a share of that. And we have discounted that share to reflect the other factors that would be available to the husband, such as illiquidity and risk.
And post-separation accrual?
No, because post-separation accrual is factored in, or yes, because post-separation accrual is factored into the straight line valuation. So if one starts as a company that is valueless on the day that it begins, and you say that it's worth £100 million 10 years later, let's just say, and you say that during the marriage ended 5 years into that, you assume that the increase in value applies evenly throughout of that, and you take the dividing line, the matrimonial dividing line, at the 5-year separation point. That's the Martin & Martin straight line approach.
Yes.
That's all we've done.
And suppose, though, Mr. Mitchell, if we were to find in the appellant's favour that, as has been indicated, the respondent may wish to run an argument quite different from the straight line valuation and would want to put matters of post-separation accrual before the court to be thoroughly tested. If Mr. Bishop's right that you can't have your cake and eat it, you can't say, my client deserves a fair investigation with the proper considerations to the forefront, those 4 principles that you mentioned,
Yes.
then it would be penalising someone who had dishonestly concealed or dishonestly failed to disclose his, in this case, rights to a fair trial, wouldn't it, to proceed on the basis of the appellant's arguments alone?
Well, I think there's 2 points. Of course, we don't say that Mr. Goddard-Watts should not have an opportunity to advance the arguments that your ladyship just postulated, and that I've clearly indicated would be available to him. The principles in the authorities do not expressly discuss how the court will treat delay when that delay has been brought about by fraud. But the authorities do say that when there has been a delay, the reason for that delay is relevant. And so I think where we end up in this debate is that the fraud is likely to mean, and should in our submission mean, that any arguments that Mr. Goddard-Watts would otherwise have available to him are deprived of the strength they would have but for the fraud. Of course, I don't say that Mr. Goddard-Watts should be deprived of his fair trial rights. He shouldn't, but I'm just saying that in the court's determination of a fair outcome, the reason why the division is taking place 12 years on has to be highly relevant, and especially when that reason is fraud. And my client has been trying for 12 years to have her case determined on the basis of full and frank disclosure, as she is entitled to do.
So the essence is, he can put his arguments, but the court shouldn't attach such weight to them because they are against the background of fraud. Is
Yes,
that it?
that's essentially it.
But he should have the opportunity to put his arguments.
Of course he should. Yes, and we've never suggested otherwise.
And are you suggesting that the Court of Appeal should conduct that investigation?
Well, as we said in our supplementary note, when we added the sections about potential disposal, what we were seeking to do was to give this court an opportunity to resolve the case in a manner that we considered was proportionate. But of course, we don't want the Court of Appeal to consider that in acceding to that invitation, it is itself doing something which is unfair to the husband or which perpetrates an injustice. Of course we don't. Which is why I'm going to be very light about that if we discuss it at all when I sit down in a moment.
Well, when you sit down in a moment, we'll have a short conference about what we're going to do about this.
Of course.
But I just wanted to know where you're standing now, as it were, Mr. Mitchell, in terms of what you're asking the court to do. You'd say in a perfect world, you'd like it all done and dusted if we
Yes.
were for the wife.
Yes.
But you recognise that the issue is whether or not that would give fair play to the husband.
Of
Because
course.
you do concede
Of course we recognise.
there is common ground between you, that the one thing that this court cannot do is to penalise the husband for the fact of fraud.
There was only one exception I was going to give you in
Yes,
relation to that.
please.
And it seems to me, it depends what one means by the word penalise, of course. But if by penalise we mean to make an order that requires the husband to write out a larger cheque, if I can put it that way, than he would have to write out without the fraud, it seems to me that the answer is there may be circumstances in which that is justified. Because, of course, as I've said several times, the court has also to consider whether or not the fraudster has benefited from their fraud and to ensure that the fraudster does not benefit from their fraud. And while we are talking about conduct, I was going to submit...
Yes, sorry.
No, not at
Sorry, I
all.
took you off.
Not at all. I was going to submit that it may very well be a useful addition to the jurisprudence for this court to indicate that fraudulent non-disclosure, particularly where it is a campaign of fraudulent non-disclosure, is something that it could regard as conduct which it is inequitable to disregard.
The difficulty potentially about the way you put the conduct issue, you say it's actually because delay is relevant, and that's
Yes.
non-contentious, and the reasons for the delay can be relevant, and if the reasons, and that brings in the fraud. But in at least Akintola and I think at least one of the other four cases, there the conduct caused the Germans, at least one or two, and the court was still saying you disregard the conduct.
Well, I think the general principle, the general policy is, as I've said, to discourage conduct for perfectly obvious reasons. That's the starting point. The statute, however, includes it and it hasn't been amended to remove it. So there are categories of cases where it will be inequitable to disregard the conduct. Generally speaking, I agree that litigation misconduct will usually best sound in an award of costs against the perpetrator of the misconduct. But not, as I say, when the misconduct is fraud and the fraudster has benefited from their fraud. For then, it is in my submission appropriate for the court to remove that benefit. And if that means that the victim of the fraud receives an award that is more generous than they would have received had there not been a fraud, in my submission, the court should not be troubled by that. That is in accordance with general civil law principles. Can I just make another couple of points, please?
Have you finished with OG?
I have.
You said mostly it's uncontroversial.
Yes. So what I want to say is, he says, Mr. Justice Austin says, it's unprincipled for the court to stick a finger in the air and arbitrarily fine a party. What I was going to say is I wouldn't characterise the sort of scenarios I'm talking about where the court is less inclined to accept an argument about delay and thus makes a more generous award to a wife than it would make if it gave full weight to the argument for delay as a fine. That is a consequence in my submission of fraud and the fact that the case is being determined not immediately after the separation, when very clearly matrimonial inquest and non-matrimonial inquest can clearly be adjudged, but 12 years on when things become harder to clearly evaluate in those terms. So I suppose an alternative way of putting that is to say that when delay causes confusion between the matrimonial and the non-matrimonial, that confusion should not diminish the victim's claim. It should, if it's going to diminish anybody's claim, diminish the fraudster's claim. Subject to that, I have finished with the conduct bundle. Is there anything any of my ladies would like me to deal with that I haven't dealt with in relation to conduct?
Anything to No, thank you very much.
Well, there's just then a handful of, in fact, I think less than a handful of other points. My learned friend submitted to you that had Mrs. Goddard-Watts known about the trust in 2010, she would have got another £2 million. But when they were determined by Mr. Justice Moylan in 2016, she got another £6 million. Now, in the context of a discussion in which we've been talking about whether a person should be penalised for their fraud, that's perhaps a surprising thing for you to have been told, because that would suggest that Mr. Justice Moylan did exactly that. He didn't look back to 2010 and say, what should she have got then? She gave him a much larger, he gave her a much larger award than she would have got. Now, in actual fact, my instructions are that that's not the correct factual analysis. So what the trusts contained in 2010 was cash and shares. Those shares, of course, had a value, but they became crystallised in the intervening period by their sale. So although I would not, of course, take issue with the idea that Mr. Justice Moylan divided the value of the assets as at the date of trial and thus benefited my client, I don't think in actual fact that is what happened.
So you don't take issue with the fact that the division of the assets took place at trial. What you do take issue with is that it benefited, or
yes, I don't think that's an accurate characterisation of the facts as it happens.
No. I understand.
Of course, I've already made the point, haven't I, that insofar as any weight is placed on Mr. Justice Moylan's judgment, and I've submitted that no weight should be placed on it because of what is said in Carr, it cannot, in my submission, be overlooked that he was himself being lied to, and that therefore there is a significant element of speculation about the conclusions he might have drawn had he known the truth at the time. And I say that that is relevant both to the 2016 valuation that he ascribed to the company, but also to the 2010 valuation, because we just do not know what impact the truth would have had on him. And while I'm talking about that subject, can I also clarify a further element of the facts? And it's in relation to the non-disclosure that you asked about that was operating at 2016. Yes, because I think that there were two limbs to it. It is right to say that Mr. Goddard-Watts did not disclose, as he should have done, the ongoing negotiations. But actually, there was a more brazen aspect to his non-disclosure, because he gave the misleading impression that the conditional offer was an outlier that was never going to lead anywhere. And on that basis, of course, it was completely disregarded by Mr. Green and by Mr. Justice Moylan. Now, that in actual fact was demonstrated to be untruthful. And in my submission, the paragraph of the judgment of Mr. Justice Holman that deals with that is paragraph 44 on page 94 of the supplementary bundle.
Is this a bit about the timing?
Yes. Yes, it's a summary. It's a summary of the rather lengthy recitation of the facts that he gives. But the point, he makes the point that Mr. Justice Moylan was to conclude that the withdrawn offer was of no relevance, when in actual fact there were ongoing contacts and the husband was looking for more. And so when that email was written on the 22nd of November, the relevance of it, I can't remember how my learned friend put it, but in my submission he didn't quite put it in a fair way, no doubt inadvertently. The relevance of the email, as Mr. Justice Holman himself says, is that the proposal did not come out of the blue to the recipient of it. That's in paragraph 44. And all the recipient said was, I'd just like to go back to my board and check one detail. So please don't be under the impression that at that time there was an opportunistic offer made by the husband, which then ultimately progressed to a sale. There had been ongoing negotiations with the husband making it clear throughout that the offers that had been received previously were not acceptable to him because they were not enough. Then when he went back with an offer that valued the company at £100 million, the recipient of that offer didn't say, that's a complete outlier, what do you mean we haven't been negotiating? They said, oh, yeah, that doesn't come out of the blue, I'll just go and clarify one aspect of it. And then it proceeded to the deal. So that deals with that point. Yes, the H&H point.
Is this H&H Mumby or H&H Coleridge?
Mumby, milady. I'm hoping that with the, not sure that I'm a fan of the loss of anonymisation in judgments, but at least when cases are called by names, I have a better chance of remembering them. At the moment, it's just alphabet soup, as milady has just indicated. So I don't need to take the court to H&H. I just need to make this observation about it. It seems to us that in a case in which my client was induced to enter into an agreement by fraud, the reliance on H&H is flipping the burden on its head and putting my client in a position where she's being required to demonstrate that what she's got was not fair. Now, in my submission, that isn't an appropriate starting point. It's precisely because fraud was not present in H&H that the approach was right there, but it can't, in my submission, be right when the underlying agreement is vitiated by fraud. Yes, Kingdon. The points that we invite the court to take up in our skeleton argument are not intended to constrain a general discretion, but as matters stand, Kingdon is, we would say, self-evidently being used by fraudsters to limit their exposure to the court's dispositive powers and to restrict the fair trial rights of their victims. And we submit that the simple points that we make, which would be from this court, guidance to subordinate courts about how to interpret their or how to exercise their discretion, and nothing more, an entirely proper thing for this court to do, simply set out matters which should be uncontroversial because they are principles which are derived from the relevant jurisprudence. Their power from this court is that they will be gathered together in one place, and whenever the court is asked to exercise a Kingdon discretion, there will be those lists of factors. I don't seek to make any further submissions about why we say this court should approve those factors. We've made those submissions already. Finally, there's the point about what actually happened in 2010. Bless you, lady.
Thank you.
In 2010, it was contended for by my learned friend that my client exchanged her interest in CBA for cash. But with respect to him, that is simply not something which, that is not a construction which it's appropriate for him to put upon the facts as they were. What actually happened in 2010 can be illustrated by the table that we put in at paragraph 27 of our skeleton argument, which you find on page 86 of the core bundle. So, whilst my client believed that she was entering into an arrangement for a roughly equal share, and that that's what she had negotiated, as you can see from this table, in actual fact, she left with 6.6 million, and Mr. Goddard-Watts left with 14 million pounds. Now, on any view, no rational basis for that distribution can be placed upon that division, because my client was mistaken because she was being misled by frauds. And in my submission, to now contend that there was a rationale for that division to which she should be held is to place far too much weight on an agreement which is vitiated in the circumstances which I have set out. Now, may I just have a moment while I make sure I've said everything I want?
Of course.
Lady, is there anything else that I can help you or any of your colleagues with?
Yes,
There is.
you can. You told me that you were going to look at the judgment, the redacted judgment that we were handed up, because you weren't sure whether or not it was the correct one.
I'm told that it is the correct one, so if you look at that document, you'll be able to see very clearly what is redacted and what is not.
All right. Well, I'd like you all to stay put, please, although it's 4:15, because I want to discuss with my ladies what we're going to do about the ancillary application in view of discussions that have taken place during the course of the hearing, not just with you, Mr.
No, of course.
Bishop, but also with Mr. Bishop. So would you just hold fire, please?
Of course.
Good start, thanks very much. Yeah, no, just want to be honest, right? Just been made. Somebody to a meeting.
You never will.
Like along the high street. And she came back to this meeting, not jealous. And she walked the entire length.
Mr. Mitchell,
My lady.
I'm going to address you, if I may, because the ancillary application was spawned by the amended notice of appeal. It seems to us, and this is not a reflection of the time I make clear, it seems to us that the ancillary application, whether we allow the appeal or whether we dismiss the appeal, is OTOs for our purposes today. OTOs because if we allow the appeal, it seems to us that we must give due regard to the submissions of fair trial rights for all, albeit that the guidance, if we gave it, may or may not indicate how those rights in terms of delay may need to be reflected.
Lydia.
However, if we dismiss the appeal, then obviously the matters in the ancillary application in relation to the application to admit fresh evidence fall away, because it's always been agreed, as I understand it, that the ancillary application goes to disposal only. Is that fair?
Yes, this is fair.
Mr. Bishop, is
Yeah.
that fair?
Yes, I do.
Yes. Well, what we intend to do, therefore, is to proceed without dealing with the ancillary application. I'm sorry, Mr. Speaker, that you've been very patient, but it's something that we could not have determined until full discussions with both Mr. Mitchell and Mr. Bishop. But thank you for your attendance and the courtesy of doing so. We will adjourn to consider our judgments. It's obviously an important case, not only for the parties before us, but also has ramifications for other cases. So therefore you will forgive us if it may not be a judgment that is delivered within a week or two, but it will certainly be delivered before the end of term, well before the end of term. That's a guarantee I'm sure that we can make. All right. So it only now requires me to thank all of the advocates in this case, also the solicitors who have obviously put in work in the background, and of course to acknowledge the attendance of both Mrs. Goddard-Watts, the appellant, and Mr. Goddard-Watts, the respondent, throughout the course of the day.
In that case, my lady, perhaps I can just conclude by thanking the court for listening so patiently to all of us.
No, it's a very interesting case, but thank you all very much.